Hi, I'm Daniel Hunt. I'm an attorney and a legal specialist in estate planning, probate, and trust law. And today we're going to be talking about do-it-yourself estate plans and whether that's a good idea. So today we're going to talk about how people try and draft their own estate planning, why they do that, and why it's probably not a good idea for them to do that. There are two main ways that people try to do it themselves for their estate planning. First is downloading estate planning documents from the internet and doing their entire estate plan themselves, or second, by trying to draft their own amendments to their existing estate plan. So why do people try and do this? That's simple, because it costs a lot less than hiring an attorney to do your estate plan. They're trying to save money, and that makes sense to a point. So why is this probably not a good idea for you to do it yourself? Well, first let's start with the internet. There's lots of websites that will provide you with legal forms for your estate plan, like LegalZoom or Nolo. These companies are very clear that they are not representing you. They are just simply providing you the forms. What you do with the forms after they've been provided is up to you. The trouble comes when you've passed away and now there's an ambiguity or a mistake in your estate plan. There is nowhere to turn to be made whole for that mistake. You compare that with hiring an attorney who will help with your estate plan, and if that attorney makes a mistake, they'll be able to look at their file, look at their notes, and see what your intent was in drafting the estate plan, and then can testify to a court to ensure that your wishes are still carried out, even though there was a mistake in your documents. Now let's talk about homemade amendments, or documents that people will try and draft up to amend their existing estate plan. So they're once again trying to do this to save money because they think, well, this is simple. I'll just draft up a change to my distribution and save myself a couple $100s from having to go and see an attorney. Some of the trouble with this is that the language that courts interpret is very specific when you are dealing with trusts and estates. And if that language is not used, or if you use language that's vague or ambiguous, this calls into question exactly what you wanted to have happen with your estate plan. What we see happen commonly is folks who take documents that they've drafted themselves and then have that document notarized, thinking that if there's a notary signature, it makes that document valid. The important thing to understand about notaries is that they are simply there to verify the identity of the person signing the document. It has nothing to do with the content of that document. So you can have a very poorly drafted document, but it's validly notarized that you've signed a poorly worded document. The fact is that do-it-yourself estate planning documents can cause a whole lot of trouble, and here's an example of some of them. Having to prove to a court that a will was executed with the necessary legal formalities, failing to take advantage of appropriate tax planning, giving gifts inappropriately, such as to minor children or beneficiaries with drug problems, alcohol abuse, or beneficiaries who are on government assistance causing them to lose those benefits. Also, increased risk of litigation. As a trust and estate litigator, I can tell you that do-it-yourself documents is one of the leading causes of litigation in trust and estates. I had an example where a client had drafted her estate plan with us as attorneys. It left everything equally to her 3 children. Very simple. A couple days before she passed away, she wrote a note on her kitchen table on some stationery that said, "My son's interest in my home is to be his and not part of my trust," and then signed it and dated it. Well, the question was, what was her son's interest in her home? Was it the entire home? That's what the son felt. Or was it just his 1/3, which was reflected in the trust? That's what his 2 sisters felt. Well, everybody got a lawyer. They all fought over it. And in the end, after all the attorney's fees, the siblings walked away with almost nothing. The attorneys ended up walking away with the estate, all because she wanted to save a couple $100s from having to go and do an amendment to her trust through an attorney. It wasn't worth it. We hope that you've enjoyed today's video on do-it-yourself estate planning. We encourage you to seek the advice and counsel of an experienced estate planner when constructing your estate plan. A good attorney is always worth what you'll pay them. And we look forward to hearing from you if you have any questions with regard to constructing your plan. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.